In the previous lesson, we spent some time talking about the idea of the automatic resulting trust. And we noted a couple of circumstances in which such a trust of an implied nature of that kind may arise. It may arise where there is not a beneficiary. It may arise where there is a certain conditionality that is placed on the beneficiary that is not met by that beneficiary. Various different circumstances may arise that give the creation of a trust of that kind of nature. The third one that we looked at was regarding a donation that is made for a purpose that is unable to be fulfilled. And we used the example of the Barclays Bank versus Quisclose Investments Limited case, in which the investment firm presented and loaned some money to a company for the purpose of paying dividends to shareholders. And obviously this purpose was had failed to materialize, owing to the simple fact that that company went into insolvent liquidation. So that's the first thing that we've been speaking about in this lesson, in the last lesson, sorry. This lesson is going to be looking at the idea of presumptive resulting trusts, where there may be a presumption that a resulting trust exists. And we'll talk about how this operates in this lesson, and then in the next lesson we shall talk about the ways in which you may rebut that presumption and the processes by which this may take place, before finishing looking at implied trust by just examining constructive trusts. So that's essentially the roadmap for the next few lessons. Essentially what we're going to be doing is talking about the presumptive trust in this video, and then talk about how we rebut such a presumption of the existence of such a trust. Firstly, though, let's just talk about what a presumptive resulting trust actually is. Well, unlike an automatic resulting trust, in which will exist in spite of the intentions of the parties of the trusts. Note here that when we looked at the previous lesson, if we just take an example of the first, one of the first circumstances in which an automatic resulting trust may arise, it was the idea that there was no certainty of object, or there was a failure to adhere to the beneficiary principle. This, therefore, requires that an automatic resulting trust exist in a circumstance in which the parties' intentions were not for such a trust to exist. In fact, clearly the party's intentions was to create a private express trust with the certainty of objects, or with adherence to the beneficiary principle. But by their failure to do so, an automatic resulting trust arises, which obviously gives that property, maintains the property transfer in the hands of the trustee, but then the trust is for the benefit of the settlor rather than any kind of third-party beneficiary. So in spite of the intentions of the parties is really what we see when we look at an automatic resulting trust. But with a presumptive resulting trust, as the name suggests, there will be a presumption. It will be presumed that its existence as being part of the intention of the parties. And the courts will approach this as a starting point where the presumption will exist, but then this presumption could be then rebutted by the parties, which is of course going to be the topic of the next video. So let's think about circumstances in which this can take place, and I want to begin with the voluntary conveyance. This is one way in which a presumption of a resulting trust may exist. And what this essentially does is tie into one of the maxims of equity here. The maxim of equity that states that equity presumes a bargain and never a gift. A voluntary conveyance is one, essentially, in which there is a transfer of the property, but without valuable consideration. Okay, so if you remember back to some of our lessons in land law, the idea of valuable consideration is a very, very important concept when it comes to the idea of conveyancing. The idea being that if you are going to get something, then you should, if there's going to be a transfer of property onto you, it should be for some kind of value. Now, what that value is not necessarily as relevant. It is often obviously money, but it's not the case that it wouldn't be valuable consideration if it is deemed to be that it wasn't a lot of money or it wasn't enough money. It is just the case that there is some kind of valuable consideration present. But a voluntary conveyance, however, is one in which there is just the transfer of a property. without that kind of valuable consideration. But if we go back to that equitable maxim, the idea here that equity presumes a bargain and not a gift, it therefore means that it is determined that a presumption of a resulting trust can exist on the part of the transferor, owing to the fact that what equity presumes is not a gift, it presumes a bargain. So when it comes to the transfer of property, if it is the case that you could assume a gift or a bargain, the principles of equity presume a bargain and rather than a gift, which means that a presumptive resulting trust arises out of a voluntary conveyance. And then, if, of course, it is actually a gift, okay, and if there is just a transfer of property without valuable consideration, then that presumption, the presumption that is cited in that equitable maxim, can be rebutted, which, of course, as I mentioned, is going to be the topic of the next video. What about the voluntary conveyance of realty, though? I made a mention to land law in the previous slide, and when we were speaking about it just then. But what does it mean when we think about the idea of a voluntary conveyance, a transfer of property without valuable consideration? How does that pertain to realty? How does that pertain to land? Well, where a voluntary takes place in regards to realty, there is a statutory determination of what happens regarding the existence of a presumption of a resulting trust. Of course, land law is a lot more heavily statutorily regulated than just the conveyance and the transfer of title of ordinary personal property. And so we have to refer to the Law of Property Act. Specifically, Section 60, subsection 3 says that, quote, in a voluntary conveyance, a resulting trust for the grantor shall not be implied, merely by reason that the property is not expressed to be for the use or benefit of the grantee. So that's essentially how we operate such an area of the law in relation to the idea of the voluntary conveyance of a voluntary conveyance of realty. So remember here, so when we think about voluntary conveyance and we think about presumptive resulting trusts, we obviously have to refer to the equitable maxim that equity will presume a bargain and never a gift. And so as a result of which, where there is a voluntary conveyance, there would be a presumption that a resulting trust exists, and it is for the parties to actually reject that presumption, to rebut that presumption if need be. The previous maxim of that equity will presume a bargain and not a gift can also be used in other circumstances, however. So this presumption can also be made in situations where one person contributes significantly to the asking price of a property, but is not listed as the legal owner. Or any legal owner. As such, there will be a presumption here that a resulting trust is created for the person to whom there has been a significant contribution to the asking price of a property. This is a presumption that exists in terms of both personal property, but also in terms of realty, as per Section 63, Section 60, subsection 3 of the 1925 Law of Property Act, and in fact that doesn't exist in these situations. So fundamentally here, we have a situation here, like let's say me and my partner decide that we are going to purchase some property. And let's say we just purchase it outright, forget about mortgages and all that kind of stuff. Let's say we've got a lot of money, and let's say I contribute 40% to the asking price. She contributes 60%, okay? She's particularly rich, let's say. And the title, the legal title, goes to her. Let's just say, on the basis of the fact that I wasn't able to make it to the signing, she signed it in her name. That does not mean, because I contributed 40%, that does not mean that I have got no rights in equity to anything related to that property. Because here, equity is presuming a bargain and not a gift. Equity will presume that I haven't just gifted that amount of money to her for her to buy a house for herself, okay? Equity presumes that there will be a person who is able to contribute to the asking price also has some kind of interest in it. And so as a result of which, the presumption of a resulting trust will arise in that circumstance as well.